Okay, Shannon, you can put us on the record.
Go ahead.
This is a matter of Carrington Berg versus Gary Berg et al. Looks like the plaintiff is present. Mr. Phillips on behalf of the plaintiff and Tara Pearson on behalf of the defendant. Did I get all that right, folks?
Yeah, yes, sir.
Yes.
All right. And Mr. Phillips, this is your short notice motion. Go ahead.
Thank you, Judge. My client is Karen Berg. She's the young lady who just turned 18. I believe she'll be a freshman at Michigan State University. Her father, this fall, her father died, I believe, in 2011. And prior to his passing, he had given a mortgage to his brother. Both of her brother-in-law, I forget the relation, but both of whom are named Gary Berg. Since my client became 18, she retained me to open up a probate estate for her father. We knew that the mortgage was outstanding, and we found that it had recently been published to be foreclosed upon. But we found that the amount claimed to be due on the mortgage was about $208,000. The mortgage itself is one between family. It indicates that it incurs interest at a rate of 0%, but it does provide that payments, such as taxes, insurance, that would have been the responsibility of decedent, if paid by the mortgagor, would incur interest at 10%. And so we do think that there's probably some interest and taxes that were paid on the property by the mortgagor, who is rightly entitled to repayment of those costs and fees and taxes with interest. We just don't know what that amount is. The property is one that sits on Michigan Center Lake. It's a small home, but we think it has good value based upon the representations of a few realtors that have been out to look at it. It'll probably sell for about $150,000, but it's probably not worth $208,000 in the condition that it's in. I have tried to get more information on what's actually due on the mortgage. I've not had any response to my phone calls or emails, save I've had the opportunity to speak to Ms. Pearson once. The first time I called, I sent her the copy of the mortgage and by an email, and she indicated to me, she replied to that email and said she'd look into it. I think that's been 2 or 3 weeks ago, and I've not heard anything since. The sale, the public sale of the property is expected to be Wednesday, this coming Wednesday. I believe it's at 10 a.m. at the courthouse. So the law about redeeming properties doesn't seem to have anything that would allow for a remedy if the, well, it doesn't seem to be any contemplation in our law that the amount claimed to be due on the mortgage is incorrect. There's nothing in the foreclosure by advertisement statutes, nor in the revised Judicature Act that deal with that. It simply states that whatever is sold, however the property is sold, that's the amount that has to be redeemed. I think I can redeem a property by selling it during the redemption period for $50,000 plus reasonable insurance and taxes. But I don't think that my client could redeem it for $208,000, which the defendant in this case would have the opportunity to submit a credit bid and not have any cash out of pocket. And so I don't have any way to proceed if the mortgage is, or excuse me, if the property is sold for $208,000, and I'm without relief except getting an order to rent the sale and determining what's actually due on the mortgage.
So you're asking the court to stay the sale until this can get resolved.
Yes, please.
Ms. Pearson?
Yes, good morning, Your Honor. I do want to take issue with one thing. One of the statements made in this motion is that counsel was called numerous times without a return phone call. That's not accurate, Your Honor. I've been out of the office on medical for 2 weeks. I have a message here. The message that I have here is April 14th at 1:35 p.m. From Mr. Phillips. Nothing about a lawsuit, an emergency hearing, a need to talk to another attorney in the office. So I just want to state for the record, I have not been ignoring phone calls, refusing to return his calls. And if a request had been made to talk to another attorney in the office, that certainly would have been done. Now to the substance, yes, there was a mortgage that was signed by Gary Leeberg to Gary Ashley Berg, his uncle, and his wife, Jennifer Louise Berg, in 2008. That mortgage provided that Mr. Berg was required to not only make payments, but to pay taxes and any other assessment on the property, to keep the property insured, to keep the property in good order and in repair. And there is a default provision that indicates that failure to do these things creates a rate of 10% per annum. Now, when it comes to this mortgage, there was no mortgage payments made. At the time of death, it was learned that no taxes had been paid, no water and sewer had been paid. The house was in a state of such disrepair, it was uninsurable. So repairs had to be made and insurance obtained. And that being said,
So let me stop you for a minute. From 2008 until after the passing of the property owner, you're telling me no taxes were paid?
From 2008 until death, it was discovered after death that none of these things had been paid. And
What was the year of death?
2011.
Oh, okay. Well, I was curious why, if no taxes has been paid, why wasn't there a tax forfeiture? But you've answered that.
Correct. So that being said, there is a significant amount due, and of course, the things that the mortgagee, my client has paid, they get back at 10% per annum. I know that Mr. Phillips, I believe, disputes that the default provision also applies to the mortgage principal. That is an item I disagree on. It's my opinion that the default provision applies to all amounts due. The matter has been submitted for foreclosure. The foreclosure process began in January, but there was some sort of error in the sheriff's office that when I contacted them after the initial foreclosure sale, they said that this file had been marked adjourned. So I had to start over. And it is currently scheduled for Wednesday. And I believe it is 10 o'clock, as Mr. Phillips indicated. So, I mean, there is no dispute that it is in default. I don't think that they can dispute that my clients are entitled to the reimbursement of these things that the mortgagor was required to pay, along with the 10% per annum. I think the dispute is whether or not the 10% per annum default provision also applies to principal. So in my calculations that I did this morning when I returned to the office, all of these things in including the costs and fees that have been incurred to pursue the foreclosure, the total amount that I have is 212,056.45. Now, if we were to eliminate the disputed mortgage principal interest, which I'm calling default interest, that still makes the balance due 149,556.45. And like I said, there's no dispute that it's in default, and it's been in default, and that items have been paid by my client that were the responsibility of the mortgagor. So I'm not sure where we proceed from here, Your Honor. Like I said, it's scheduled for tomorrow, or I'm sorry, for Wednesday. I don't.
So
and I did, and it is true. I'm sorry.
Go ahead.
Sorry, I didn't. I was going to say, I do know that when a foreclosure is in process, that during the redemption period, they do have the ability to list and try to sell the property for the amount of the foreclosure. So that right is still retained.
So what I was going to say is, I mean, you could certainly adjourn your sale from week to week. I mean, that frequently happens.
Correct.
At least until Mr. Phillips is satisfied that indeed what you're claiming in terms of insurance, repairs, taxes, etc., that have been paid have in fact been paid. I mean, if they have, you're absolutely right. You're entitled to foreclose as to all of those items. The provision regarding the 10% interest rate, I don't see that you've got any reasonable argument that applies to the mortgage balance itself.
Okay.
It's very clear if the mortgagor makes default in the payment of any junior or senior liens, any of the aforesaid taxes or assessments, or in procuring and maintaining insurance as above covenanted, that the mortgagee gets to pay those and gets to collect this 10% interest rate. I don't even think you've got an argument that applies to any improvements that were made on the property, because it doesn't address those things. Certainly, if they made improvements and repairs, they ought to be able to recover for the cost of those, since the obligation to keep the property in good repair is indeed mandated by the mortgage. I think. Let me make sure I said that, assuming that it does say that. Yeah, here it is, 6. Keep the improvements erected, intact, in good repair, promptly pay for all repairs.
With regard to that provision, Your Honor, it's our position that to procure the insurance, it was uninsurable in its condition. So there were no improvements made. Yeah.
Yeah, I don't have a problem with recovery of whatever had to be done to make the property in compliance with this provision to keep in good repair. But it doesn't appear that the interest rate in the 4th paragraph applies to that. So I think an adjournment until you can provide Mr. Phillips with verification of what those items were doesn't really hurt anybody. If indeed the total amount of all of these plus the interest on the debt exceeds the value of the property, my guess is that Ms. Berg is unlikely on behalf of the estate to incur any more funds on this. But I think it's reasonable to give them a chance to do that. Let me ask you, how much time would it take you to provide Mr. Phillips with evidence of the various expenses that were incurred that are covered by the mortgage?
Well, like I said, I'm back in the office today and I can scan him all of my spreadsheet. When it comes to getting in touch with my client to sign an affidavit, I have to get a hold of her and see when she can come in. But I can give him my numbers today.
Bless you.
Oh, thank you.
Bless you. So here's what I'm going to do. I'm going to order that the sale be adjourned from week to week until such time as Mr. Phillips is satisfied of the amount. And at some point, if you think Mr. Phillips is dragging his feet and you've provided everything reasonable, just simply ask for a hearing on this stay order.
Okay.
And without filing a motion,
Oh, okay.
just request a hearing date from my civil secretary, Patty, and we'll get you back on the docket. Hopefully it's something you'll be able to resolve. I'm sure Ms. Berg doesn't want to spend any more attorney fees than she has to if there's nothing here that's salvageable. And I'm sure Mr. Phillips will deal with this promptly. If not, you can ask for another hearing and just adjourn your sale from week to week.
I will do that.
May I be heard
Mr.
briefly?
Phillips? Sure, go ahead.
Judge, I did call Ms. Pearson's office a number of times, and I'm sure. Well, I wasn't told that she was out. If I would have been told she was out or otherwise unavailable, I'm sure I would have asked to speak to an attorney. But I didn't mean to indicate without good cause that Ms. Pearson wasn't getting back with me. Now that I understand more fully what the situation was, I can see how I misunderstood what I was getting when I called the office.
No problem. Can you prepare an order consistent with what I've stated on the record today, Mr. Phillips?
Yes, Your Honor. Yes, Your Honor. I wrote down that a sale will be adjourned from week to week until plaintiff satisfied. And if I'm dragging my feet, Ms. Pearson can simply ask for a hearing date on the stay order without having to file a motion, but simply by calling the clerk.
Yeah, you don't have to put anything in the order about dragging of feet, okay? If Mr. Phillips fails promptly to respond, probably might be a better term to use. Okay, Mr. Phillips, I will watch for that order. Thank you, counsel.
Thank you, Your Honor. Have a good day.
Likewise.